crucial element in many defamation cases is the protection of a journalist's sources. Some cases are taken with the sole aim of discovering a journalist's source for a story, often a whistleblower. But journalists strongly resist attempts that they should reveal who their sources are. This is a matter of professional ethics, but equally an issue of journalistic pragmatism. Once a journalist reveals his or her confidential source for one story, their reputation will be tarnished and other potential sources may not want to talk to them. The European Court of Human Rights has held that the protection of a journalist's sources is essential to the right to freedom of expression. In the landmark case of Goodwin versus the UK, concerning a British journalist who refused a court order to reveal his sources, the European Court held that protection of journalistic sources is one of the basic conditions for press freedom, as is reflected in the laws and the professional codes of conduct in a number of contracting states, and is affirmed in several international instruments on journalistic freedoms. Without such protection, sources may be deterred from assisting the press in informing the public on matters of public interest. As a result, the vital public watchdog role of the press may be undermined, and the ability of the press to provide accurate and reliable information may be adversely affected. Having regard to the importance of the protection of journalistic sources for press freedom in a democratic society, and the potentially chilling effect an order of source disclosure has on the exercise of that freedom, such a measure cannot be compatible with Article 10 of the Convention unless it is justified by an overriding requirement in the public interest. The Court found in a journalist's favour, as it has in a number of subsequent similar cases. Yet, the requirement that a journalist prove the truth of a defamatory statement may well impose an ethical dilemma that the journalist can only resolve by failing to offer such proof. Of course, the journalist would not be compelled to reveal the source, but the penalty for not doing so could be the loss of a defamation suit. The independent representative on freedom of the media for the OSCE has specifically recommended how courts should address situations where journalists may testify in court proceedings. She has said, "Journalists should not be required to testify in criminal or civil trials or provide information as a witness unless the need is absolutely essential. The information is not available from any other means, and there is no likelihood that doing so would endanger future health or well-being of the journalist or restrict their or others' ability to obtain information from similar sources in the future." This mirrors the standard established by the International Criminal Tribunal for Yugoslavia in the case of Brjanin, in which Washington Post journalist Jonathan Randall refused to testify to protect his sources. The Committee of Ministers of the Council of Europe has recommended that journalists should not be required to testify in defamation cases. In a recommendation dating from 2000, it stated that in legal proceedings against journalists on grounds of an alleged infringement of the honor or reputation of a person, authorities should consider, for the purpose of establishing the truth or otherwise of the allegation, all evidence which is available to them under national procedural law, and may not require for that purpose the disclosure of information identifying a source by the journalist.